Oh, you're missing echo.
David Woodard. All right, thank you.
What do you think about the final situation? Resolution to it? Yeah.
All right, state. I'm David Woodard's client, Mr. Insuriaga. The defense has filed a motion asking that the removal of full house arrest on GPS.
Would have an objection to that, given the charges. I would have to call the victim right now just to confirm as well, but let me do that and I can get back to you. Is that okay, Ron?
Yes.
Thank you.
All right, Mr. Woodard. The state is going to call the complainant. And so as soon as they speak with the complainant, I'll take your motion up.
Okay.
All right, thank you. I'll put you both in the waiting room. All right, is there anyone else who's ready? All right, Gilbert Avalos.
By the judge, I conferred with the state, my client, they made an offer. We've been negotiating for a while. And I was hoping you could give us another 3 weeks. I can go through videos and check on a victim.
All right, so today is supposed to be the plea deadline date.
It is.
I can recall it for Thursday. And that will be the final plea deadline date. All right, Ms. Ferguson, recall this for September 18th. All right, thank you.
Thank you.
Once you sign the reset form, you're excused. All right, who's next?
It is page 3 down.
Thank you. All right, while we're here on Ms. Dottie.
She went to inpatient treatment.
Mhm.
You wanted her to come back afterwards, kind of a status check, see what she's doing, make sure that she's got what she needs to be successful.
All right, and you're still residing at Starlight?
No, I've come home last Monday.
All right.
I've been on full house arrest since then. But I'm doing an IOP program with Starlight.
All right, and has a release been signed with probation? Probation, have you had a chance to confer on how she's actually doing?
Judge, we did last week.
Okay,
My understanding is doing well. No issues at this point. We have to get from Starlight Recovery.
Mhm.
I can obtain a release that I get one signed today.
Okay.
If the court. And
all right, so she's been released from Starlight Recovery. So is she living on her own? Where is she living?
Yeah, I'm living at home in my apartment again.
All right. And who all lives there?
just me.
And what is the requirements that Starlight has you doing?
So I'm doing the 24 course IOP program, 3 days a week, Wednesdays and Thursdays from 6 to 9. And once I complete that, then, and they have me seeing my psychiatrist, my therapist, and my primary care regularly.
Okay.
So I'm on medication.
And have you given probation a list of those meds?
I just got my new probation officer. I got a letter in the mail, so I have a meeting with him on the 29th. And I sent the lady that's in charge of my IOP, I just gave her the contact information for my new probation officer, so she could be sending him updates and stuff as well.
And Judge, I did forward the email I got from Starlight to both the completion certificate, an indication that she had done very well, was very interactive with them. Her participation was very positive. They had assigned her certain leadership roles, so she seems to have done well while she was there.
All right. And so you're saying this is a 24-week course?
It's a 24 courses, so 6 to 8 weeks.
Okay.
And then they do random drug tests as well.
And probation, are you going to accept Starlight's drug tests or do you still want to do your own?
I would want an independent judge.
All right. So you'll still need to do drug testing with probation.
That's fine.
Is there anything else probation?
You know. If you want to make conditions for monthly, you can.
How often are you being UA'd at Starlight?
It's random, so they set up to 4 times a month. It could be, but they didn't specify.
All right. So what we'll do is we'll do monthly UAs with probation. And you need to make sure that you do a release so that probation will have access to the UAs that they're doing.
Okay,
All right. Is there anything else you need from the court?
can I get my ankle monitor on?
Uh,
Cause
what-
I was supposed to get it off July 30th, but then you had me keep it on while I was in treatment
yes,
and I.
because I mean, and let me explain something to you. When people are placed on GPS, your attorney will tell you there's a step process for me when I remove it. Because if, we were here in July, there was a motion to revoke. The state withdrew the motion because you were doing Starlight and you were doing other things. So the GPS, what is the status of it? Is it tracking only? What is
It's
it?
Fort House, but how long have you had it on?
Since May.
All right, so here's the thing. It is at full house right now. State, do you want to do tracking with a curfew or do you want to start out with partial?
Does she have employment?
No, I'm trying to get employment, but I haven't been able to since I've been on full house arrest.
I'll agree to partial for employment purposes to allow 8 to 5, allow her to go out and look for a job. And then if she finds a job and gets a different schedule, we can return to court to maybe get her a better schedule.
And Judge, I'd remind you the GPS was a sanction.
Mhm.
And then so we went ahead and did that. And so she did serve out that sanction. We did keep it on there to allow her to attend Starlight, know where she was at and make sure she stayed. At this point, I would ask if we're gonna keep it on, that we reduce it down to tracking only. But, the plan had been as a sanction to keep her on till certain dates. And so I'd ask the court to be mindful of that.
The, minute conditions that were, done back in April were for her to have the GPS monitor for 90 days. There has not been any, at this point, hasn't been any type of violations, Judge.
Right. So this is what I'm going to do with regards to GPS, and you all will have to figure it out. I'm going to do tracking with the GPS, but with the curfew. And then in 30 days, your attorney can come back, and if there are no violations, the court will consider removing it. Okay, so you all discuss the tracking with the time frames, and it can be Monday through Sunday, and you all come up with a time.
Yes, sir.
All right.
Okay.
Is there anything else you need? All right, keep up the good work, okay?
Thank you.
All right, you're welcome. And Luis, we'll just recall this in 30 days. That way we can take care of that. Ms. Ferguson, I need a 30-day reset. Is October 16th? Okay. And if she's employed and there are no issues, she can appear by Zoom.
Okay.
You're welcome.
Excuse me?
Yes, once you all make sure you get the time frames. And she signs the reset form.
Time frames are in, Judge.
Hmm?
The time frames are in.
Oh, you've already done that with the curfew with probation?
Yes.
All right then. And what times did you all agree on?
Curfew from 10 PM till 6 AM.
Okay.
I think the one myself, Judge.
Right.
Sleep.
Yes.
May I please see a copy of Mr. Woodard's motion? He didn't serve it on us electronically for Instagram. Thank you, Your Honor.
Anyone else ready?
Ready with on? Page 4 down.
Freddie Lozano.
Ready.
Since you have, I just want to make sure that's a. That's a.
Hello, good afternoon.
Yeah.
All right, what is happening with this case?
There are two outstanding discovery issues we just need to resolve, Your Honor. One is the results of the defendant's vocal swab that was obtained from him. And the second is I need to order a copy of the hospital records from Metropolitan Methodist that the victim had responded to after the incident and disclose those properly to defense.
All right, and how long will that take?
The subpoenas went out during the lunch break. I would imagine it shouldn't take too long, maybe a 30-day reset. I think we should probably have time to give it to defense.
All right, Norma, 30-day reset on Lozano, please.
Yeah.
And state you'll need to be prepared to tender an offer at that time.
Yes, Your Honor.
And just, and for the record, we haven't received any video to this case, and I'm assuming it's because it's not in there.
It should be there. If you don't have it, just bring me a flash drive. I can download it for you.
Okay.
All right, thank you. Do you have any questions, sir? All right, thank you.
Once they get on the phone. All right. Okay.
All right, who's next?
Page 5.
All right. All right, yes.
Your Honor, at the lunch break, I was reviewing the state's indictment and discovered that one of our dates in the priors is incorrect. So the state will be tendering a dismissal to refile, as well as we are missing a surveillance video.
All right, any objection to the dismissal?
Yes, Your Honor, the defense would object. It doesn't look like there is is also a witness available that would be needed to testify for actual compensation purposes. We would object we would object to dismissal on that counts. We don't object to dismissal, but we would object to the state refiling.
All right, so I can only address matters that are before me, so because there's no objection to the dismissal, the court is signing the dismissal in 2025 CR 009248.
Yes, ma'am.
Is this the only case your client has?
He has a blue warrant.
Okay. PR, sir.
Thank you, Judge.
All right, thank you.
Thank you, have a good day.
You too. Who else?
Person.
I'm sorry.
Nashia Harrison?
Judge,
Yes. Hi.
it could be the judge, I hate to even mention it here all this time here. My client already got sent back. I did confer with the state. This is my first hearing. I'm gonna do a motion to press on some issues here, but I've done all I can do today.
Has the state presented an offer?
Yes, I already conferred with the state judge.
Okay. Norma,
Yes.
set this for a plea deadline date in 3 weeks.
Will that be the suppression hearing date to the judge? Or is that-
Oh, you're filing a motion to suppress?
Yeah, I don't need to confer. anymore.
State. Defense says they're filing a motion to suppress on Harrison. Is it, stop search warrant? What is the issue? That you see?
It's essentially a detention issue, how they got into the dwelling. Major
All right,
problem.
so a search issue?
Yeah, the consent. It was an apartment that got my client coerced her into getting in there. She's a victim of the person they were looking for. It's all kind of,
All right, state on, and we're not on the record. I'm just trying to figure out what the issue is. It's, Nashia Harrison. So is there a search warrant in this case or no?
no,
2 seconds and I will find out.
there's a ton of video. I'm learning how to download all that stuff.
I don't believe that
There's something, arrest warrant.
I don't believe that there's a search warrant for them to gain an entry into the residence. I believe they were running surveillance and then observed the defendant associated with the room, and then they go kind of do a knock and talk and then obtain a consent to enter into the room.
All right.
Actually, they went to the leasing management, coerced my client to go back to her room where she was at and pretty much forced her to go in. So
All right, so,
consent issue.
all right. So here's my question. Is this gonna be a jury trial or not a jury trial? Is the motion to suppress gonna be dispositive or not dispositive?
Oh.
So, yes. Yes, so if the motion to suppress is not gonna be dispositive, then the
not.
court can carry it. So, okay. All right, so Ms. Ferguson,
Yes.
on this case, I need a jury trial date. It's a drug case, is that correct?
Yes,
Yeah.
Your Honor.
All right, so it should be probably 2 days.
I agree, Judge.
And so we'll set it for jury trial.
And I just have my hearing on that date, trial.
Mhm.
So you're running with the day trial?
It's gonna run with trial. So we'll do a jury selection and we'll go with the trial.
Perfect, I like that.
Okay,
Thank you.
you're welcome.
Thank
October 28th.
you, Judge.
All right, so your jury trial date will be October 28th.
Thank you.
And if you could sign a acknowledgement of discovery before you leave.
Sure.
All right, thank you. All right, who's next? All right, who are the people in the box who are dressed?
Mr. Michael Meadows, fine.
Okay, all right, thank you.
And I think Roger got his sign for. What's the name?
Yes, that's correct.
Oh, Martinez.
Yes, there's one of my.
Yeah, that's
All right, David Garcia, he didn't address Richard Cantu, did he? Okay. And Norma, I need you to contact Neil Kalfas.
I have one on Westbrook, but even in the middle of a crazy federal trial out in somewhere with Thomas Jane Henry.
No, but where is Mr. Westbrook?
Oh, he's in Carn City, according to Mr.
So is he in,
He's in Geo.
okay. All right, Norma, so then on Mr. Westbrook, recall him. And you say Neil is in a federal trial?
Yes. Not one out that found. Quite.
All right. Yes. Norma, recall this for the second week in October. And state if you confer with Ms. Ferguson on a jury trial date, because actually it was set for jury trial on August 5th, but then he was picked up by the feds. And that jury trial date that I'm going to give you is just a tentative date because we can't do anything until he's released from the federal side. All right, what date, Ms. Ferguson? All right, state, are you okay with October 13th?
Yes, Judge.
All right. No, you can keep it on a Monday because I don't think the federal government is going to be done with him by that date. All right, what is happening with Oscar Patlon? All right. So from page 1, then we have DeLeon's client, Chumley's client. Page 2, we have Pettis's client. All right.
That was a client.
Yeah, that's been set for September 23rd. Yeah. And then we need somebody to make an announcement for Priscilla Garcia in the hallway. Yes. And then we have Alba on page 4 with Martin Guerra. All right.
Norma, I thought we best of this Norma.
No, I appreciate you.
Just to come back, you were paying for a lot of. Okay, back. I was going to have this and that.
No, so here's the thing. The rule for this court is that when we have people who are in custody, if the attorneys have not made an appearance by 11:30, they're going back. They're going to be recalled for the next day. If it's on a Tuesday, they're going to be recalled for Thursday because the deputies need to get people back to the jail at a specific time. Otherwise, the deputies here have to drive them back. And for the amount they're paid, that's just a bridge too far. And also because we usually have jury selections. All right. Okay. So who is ready? Which case? Thank you. Hello,
Good evening, Your Honor.
good evening. How's it going?
I'm blessed.
All right, so we're scheduled for jury trial.
Judge, I'm going to announce ready for this setting. This is really my second appearance on, because he had Mr. Lyles before.
Mhm.
And as I was preparing, well, actually, last week I was called to Houston for a potential trial, and I was preparing on that all week, and then it went away on Friday. But I was noticing there's 1,800 pages of CPS records that I really need to review before we go forward on a trial setting. That's
So
gonna be-
when were those turned over?
I don't believe they have been turned over.
Why not?
Am I correct in that?
I do believe there was, Mr. DeLeon is the second defense attorney on this case. I do believe they were turned over to the previous defense attorney, twice. And so.
I haven't
that's
heard from
where
Mr.
we're at.
Lyles.
All right, so I will tell you what the court is aware of with regards to CPS records. Even though it's 1,800 pages, probably 100 of those are information that's new. Because with CPS records, what ends up happening, every hearing that they have in CPS court, for example, if they were to say on June 1st, it was raining, right? And that's the information from June 1st. They'll have another hearing in August, and then they'll say on August 1st, on June 1st, it was raining. And then they don't have any new information. So of those 1,800 pages, probably 100 of it is new information. The remainder is not. What I'm going to do is I'm going to recall you all tomorrow at 9 a.m. for jury selection. And counsel, you're telling the court you have not received those records, review them. And then the court will consider whether or not, if the state is seeking to have those records used, the court will make a decision on whether or not they're allowed to use them.
That'll work, Judge.
All right, so we'll have you back here tomorrow at 9 a.m. for jury selection.
Okay.
Ms. Ferguson, Mr. Mitchell is to be brought dressed for trial tomorrow, 9 a.m. All right, thank you.
Sounds good.
Thanks, Judge.
All right, we'll take it back to a coffee line.
All right, Mr. DeLeon and state. So I can release this jury and have them back at 9 a.m.
That's fine.
All right, because if we do a different panel, then we're gonna end up starting late for jury selection because they won't have them up here till about 10:30.
Are you gonna bring this panel back tomorrow?
That's my question. Do you want this panel brought back tomorrow?
No, I don't.
Okay, all right,
Poor people.
all right. I'll then, Norma, can you call downstairs and tell them I will need a panel immediately? I know they won't be able to do it at 9, but the first panel they send out, if they can send them here. All right, thank you. Okay. All right, thank you. All right, and on that case, have you done the acknowledgement of discovery? I know the previous attorney signed it.
No, we haven't done that, Judge. We will do that.
Okay.
More than likely going to the jury for punishment
Okay,
with a continuing sexual abuse.
okay.
Yeah.
All righty.
Okay.
All right, thank
The
you.
rest out.
Who else is ready?
Judge, I'm ready on Mr. Cole. The courts. It's an MTR.
All right, could I see Cole? Are you ready to proceed on the motion to revoke?
We are, Judge.
And then Deputy Laura, after this, I'll go outside with you. Hello,
Hey, good afternoon, Your
good
Honor.
afternoon.
Bless, how you doing?
Well, I'm doing great. I'm glad you are blessed. It's good to be alive.
Some lessons for fun, though, you know,
Mhm.
that's fine.
It is MTR.
It's a motion to revoke. All right, so
My fault. I should feel.
that's okay.
Is that free?
All right.
Okay.
Yeah. All right, James Cole.
Tell me, Judge.
All right, thank you. All right, the court is calling 2019 CR 9039, State versus James Arlington Cole. Can I have parties announced? For the defense?
Michael DeLeon for Mr. Cole.
Ashley Jones for the state. Apologize, Judge.
Michael DeLeon still for Mr. Cole.
All right, and are you Mr. Cole?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same James Arlington Cole who was placed on deferred adjudication in 2019 CR 9039 for the offense of aggravated assault with a deadly weapon on February 12th, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation condition number 4.
Oh, and I'm sorry, could you announce for the record?
Rick Pena for the state of Texas, my apologies.
All right, you may proceed.
Violation of condition number 14G on or about the 31st day of May 2025 in Bear and or Harris County, Texas. The defendant, James Arlington Cole, did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program in a violation of condition number 14G.
How do you plead to that? True or not true?
True, Your Honor, I had.
Just one moment.
Judge, we're gonna be doing true with an explanation.
All right. So with regards to the other violations,
State will waive the other 2 violations, Your Honor.
any objections?
No objections.
Did you understand by pleading true to violation of 14G, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 14G?
Yes, ma'am.
Court will find 14G true. Is there proposed agreement?
There is not, Your Honor. Both sides are going to go open to the court with our recommendations
All right, state, what are you recommending?
to revoke the defendant's probation, adjudicated guilty, and sentence the defendant to 6 years TDC.
All right, and defense?
Judge,
We'll have witnesses or,
no witnesses, Your Honor, just argument.
all right, what are you
We're
requesting?
going to be requesting for Mr. Cole to be placed back on deferred adjudication, and we like to explain what was going on with the MTR.
All right. Let me hear
And,
explanations.
let me
Yes.
explain. First of all, on the BIP program, his deferred was transferred to Harris County. That's where he's from. He completed a lot of the BIP program over there. He was exited from the program because he didn't make his payment for the BIP program. Our best estimate is that he completed maybe almost 90%. He was talking about graduation.
So here's my question.
Mhm.
Do we have proof that he was exited from the program for non-payment? Now you can lower your hand. So here's the thing. Let me explain something to you. You're saying I was exited from the program because I was unable to pay. Okay. Your client, your attorney saying he was exited from the program because my client told me he was unable to play. It's like, where's the proof?
Can I speak, Your Honor?
Well, let me just be clear. So is this for failure to pay? That's what
That
is
is, that is our understanding, Judge. I don't know if probation has any more information beyond that, given the fact that this case.
well, let's call probation in Harris County.
Okay.
And let's see if they'll zoom in. And if this is about payment, then we'll see what's going on.
We can find out.
All right?
That'll be fine. Okay, Judge.
Yes.
You have larger support from the bid program. And on this, 2024, for the month of May 2024. It indicates he attended 11 of 12 sessions. And at the bottom of the report, it indicates there is an outstanding balance. However,
Mr. Dill, can you, I can't see her.
however, I don't have any other updated progress after that. From the BIP program itself.
All right, state, have you reviewed that?
I have not reviewed that, but I'll take her
All right,
word
so if
for it.
y'all want to review that, what I can tell parties is this. If the only allegation the state is going on is 14G. And it appears from what Ms. Abrams has said, the progress report she received, there were 12 classes for BIP. He completed 11. And then they say that there's a balance that's due.
Yes.
And I'm assuming the balance that's due is not a balance of another class, but of funds. And what I can tell parties is I don't see how it will be appropriate to revoke him if he's done 11 BIP classes. He only has one more to do
Mhm.
and he owes a balance.
And court wants additional arguments, I'll go into it, but I'll wait for the court.
May state so back for motion.
Yes,
Thank you, Judge.
sure. You want to confer with the state as well?
Yes,
Okay, thank you.
okay, have a seat for a little while, okay?
And is that for family violence? All right, I'll take that up right after this. Can you let him know? So are you all ready?
Or Judge.
All right, Mr. Cole? Is there anything else?
I have an argument if I could make before you make your ruling, if that's okay.
Yes.
Reason why state's recommendation is what it is because he is on probation for a 2018 offense of aggravated assault with a deadly weapon. 3 years later, he picks up a misdemeanor assault, bodily injury, married co-had, which unfortunately we could not go forward because that victim was uncooperative, but it was a different victim.
All right, so I will listen to what you have to say, but let me explain something to everybody.
Yes.
Y'all are only going on 14G. And that's the only thing that I have before the court. Now, I see the motion to revoke and I see there is a violation of number 1. There's a violation of 14U, but the only thing I've been presented with is a violation of 14G.
Yes, Your Honor.
And he's on deferred adjudication. And 14G, and if there's a disagreement on the facts that I've been given, let me know. The facts that have been given to me about 14G is he didn't complete his battering intervention and prevention program. There were 12 classes. He did 11. They kicked him out of the program because he didn't have money and they're waiting for the balance. And then I guess he can take the final 12. That's what I'm dealing with. If people want to go on other violations, I'm willing to hear that, but you all have just gone on 14G. And what I have on 14G, I don't, well, it would not be appropriate to revoke someone who's done 11 of the classes. They only have 1 remaining. And the reason why they didn't do that 1 is because they didn't have money to pay for it. Now, if somebody wants to present some information to me that he could have paid for it, he just chose not to. He won the lottery. He chose not to use it for that. He chose to do something else. I'll hear that, but I'm just here for 14G.
And Judge, he did not win the lottery. In addition, Judge, he was doing really well the past year and a half. This is his first MTR. He's on deferred. He's employed. He has a CDL. He's a truck driver. He hasn't tested positive for any substances. He's tested all the time and come up negative. If you test him today, Judge, just in case there was any doubt, he would come out negative. He's been in jail in custody for about 30 days already. And we believe that if and he is motivated to get back on deferred. If you place him back on deferred, Judge, he's going to do anything the court wants him to do. If you want him to do the BIP course all over again, he's more than willing to do it.
Well, I don't think it would be appropriate to redo the entire course when he only has 1 class remaining. Is there something else, State?
I make one more additional argument, Your Honor.
Yes.
The violation of the BIP that Your Honor is aware of occurred over a year ago, and as Mr. DeLeon said, his client is gainfully employed as a trucker, which I would assume pays well, and he's had a year in which to try and take care of that particular non-payment to the BIP issue and has failed to do so up to this point in time. Additionally, Your Honor, if Your Honor does not feel like revocation is appropriate, state would, and if Your Honor is considering continuing on probation, state would ask that Your Honor add a jail sanction to his probation that begins today.
All right. This is what I can tell everybody. there's one outstanding class. Am I correct in that?
Correct, Judge.
It appears so, yes, sir.
And this motion to enter adjudication of guilt and revoke community supervision was filed on June 12th, 2025. And we'll have to look in to see when he was actually arrested on this, because sometimes motions to enter adjudication of guilt, they're signed, they're filed, and then if he was in Harris County and if he were arrested in Harris County, he would have needed to be brought back to Bear County. So these are your choices. You know yourself better than I do. You know yourself better than your counsel does or the state does. I do realize that the state is only proceeding on 14G. I don't understand about this thing from North Carolina on June 8th, 2025. But these are your choices. I can continue you. Or I'll sentence you to 2 years in the prison. Those are your choices.
Which one do you want? You want to be continued? You want to?
Well, I can tell you right now, based upon what's in the motion to revoke, maybe truck driving is not for you. Because the violation, and I'm not considering it, the state didn't present any information. But I see it where it's alleged to have been committed in North Carolina. And I think that's related to he's driving his truck in North Carolina. So maybe he should not be allowed to drive in other states.
Absolutely. And I've had a discussion with my client, Your Honor, and if placed back on deferred, he knows that, you know, if he gets in trouble again, he's gonna be back in front of the 187. So he understands there can be, you know, bad consequences. So, but he has reiterated to me, he does want to be placed on deferred, back on deferred, and he'll do whatever the court asks him to do.
Well, if he wants to be continued and deferred and continue to drive a truck, I'm not going to allow him in the state of North Carolina.
I think he'll agree to that easily.
Is there anything else?
If your honor would, as you just mentioned, we can see it when you provide evidence of the number one, but just consider the fact that even after doing 11 of the 12 BIP courses, he picked up that number one. That's all I'm gonna say.
Well, I don't know if that rises to the level of preponderance of the evidence, which is the standard of proof and motions to revoke. I don't know if that's something that rises to the level of proof beyond a reasonable doubt. If it's for a jury trial, I just see that there's something in North Carolina.
I present this to your honor if your honor would be willing to look at it over Mr. De Leon's objection.
Judge, I'm gonna object to that because they waived the number one allegation. So that's something for the court not to consider.
All right, that'll be sustained. So I'm to deny the motion, alternate amending conditions. There's to be no contact with the state of North Carolina unless he's ordered to be there.
Okay,
Legally ordered to be there, not by your employer says you need to drop off a load in North Carolina. You're not allowed in the state of North Carolina unless in the state of North Carolina, they have a hearing for you in a court of law.
Yes, ma'am. Understood.
Is there any other conditions you request state?
For the defendant as well. Part of the terms of this probation to have no contact with Tamisha Singleton. And that's, if I can spell it for the record, Your Honor.
You said Tamisha?
Yes, TAMESHA, and then Singleton, SINGLETON.
We have no objection to that, Judge.
All right. All right, so there's to be no contact with Tamisha Singleton, no residing with minors, no unsupervised contact with minors. And you're gonna restart the BIP course.
Yes, ma'am.
And Ms. Abrams, that needs to be restarted within 15 days. Is there anything else?
Nothing else, Your Honor.
Thank you, Your Honor.
All right, we can go off the record. Here's the thing. I didn't really consider that number one because the state didn't proceed on the number one. But I did allow you no contact with Carolina because of course you see things and it's alleged to have been committed in North Carolina. It appears that you are a person who should not be in a relationship because you don't know how to keep your hands to yourself. So you need to work on self and figure out why you may or may not, because I don't know anything about that case, are abusive towards people you claim to care about. Because at some point in time, you're going to run across somebody who's somebody's brother, mother, or sister who's going to be very upset with you that you're mistreating their relative, and they're not going to tolerate that. And if something were to happen, you know what people are going to say? Oh, well, you should have kept your hands to yourself. So I don't know why you can't do that. Do you know why you're unable to do that?
Your Honor.
Tell the judge what you can do in the future.
Well,
Yes,
no,
ma'am.
not what you're going to do. No, not what you're going to do in the future. Why can't you keep your hands to yourself? Why do you keep being abusive towards people you claim to care about or claim to love?
It wasn't my intention.
No, I don't want to talk about your intention because you're here. And the reason why you're here is because you cannot keep your hands off of people that you claim that you love. So I don't want this, it's not my intention, because it is your intention. You know, maybe after something happens, people have regrets. They want to cry, buy somebody flowers and say, I love you, it'll never happen again. And then the next thing you know, it happens again. And then people start gaslighting people, making them think it's their fault. And then they're trying to walk on pins and needles to make sure that you're happy so you won't explode and act crazy and proceed in violence and not in love. So why are you doing this?
Your Honor, I'm not doing it,
No, you're
Wait.
here on deferred, that the state agreed for you to have deferred on an aggravated assault with a deadly weapon. That wasn't done in love. And then you have the North Carolina case, which I am not taking as true because nothing is presented. That's not done in love if something happened. So I don't know. Maybe you want to be in prison, and then if you go to prison, you know what will end up happening? And people think I have some control over what happens in the prison. I don't. If I were building a great prison, you know how I would build it? Each inmate at the prison would have their own room. And you know why? Because that would make it easier for the guards. You have your toilet in your room, your bed in your room. You can sleep, not to watch your back for other inmates who probably want to do you harm. So we are back to my question. Why do you continue to do this? Maybe you want to go to prison.
No.
And you can get into prison and you could probably end up fighting over there. Maybe you'll win some, maybe you'll lose some. So why are you doing this?
Well, I really don't know, Your Honor. I'm just gonna be honest with you.
Hope so.
I'm gonna be honest with you from my heart. And I really don't be in a relationship with women. It just, they be with me because of who I am and what type of stuff I do, like work and stuff like that. So it really don't be out of love or passion or.
Oh, no, here's the thing. I understand. And I will tell you, I understand based upon cases that I've seen as a prosecutor and defense attorneys, that women sometimes end up in relationships with people and they bring their children along for their relationship. And I'm always thinking, why have women's standards fallen so that they're accepting of someone who's been to prison and they bring in relationship? For example, with you, you have an affirmative finding of family violence. You're on deferred adjudication for aggravated assault with a deadly weapon. You would think a woman would see your history or question you about it before getting involved with you. And they would say, you know what? I have children. I don't want to be in a relationship with you right now. You're on probation. Obviously, you have anger issues, but no, I see it all the time. You know what some women will do? They will meet a guy, even though they have children, they will meet a guy at the club on Friday night, bring them to their home, and they never leave. And the wife will, the girlfriend, the person who picked them up, they'll go to work on Monday and leave that man with their children who they really don't know. And then a child ends up dead or a child ends up raped. And then they're like, oh my gosh, I had no idea. And so with you, you're a walking red flag. And some woman allegedly in North Carolina thought that you would be great. And maybe because you're a truck driver, and I know how much money truck drivers make because there are people in my family who are truck drivers. And who knows, maybe they see you as a paycheck and you think because they see you as a paycheck, you're allowed to do whatever you want to do. You're going to end up, if you continue on this path, you're either going to end up serving a lot of your life in prison, and then you can fight with people at the prison because that usually ends up, that's what happens. I have no control over that. Or either you're going to meet somebody whose father is going to be very upset with you, or their sister or their brother. You understand? I went to a church service, and this guy who was being honored as Christian of the Year, he's been married, I think, for like 30 or 45 years. His wife's like, everything you hear about him is exactly true. I don't have any problems. He's a great guy. So he spoke and he said, people ask me, how are you able to be such a great guy to your wife? And you know what he told them? He said, because I'm a man of faith and I believe in God. And I always think of God as being her father. And I don't want to answer to him because he said, if I treat her badly and her father comes to talk to me, which he says is God, how am I going to respond to that? So maybe if you believe in a higher power, you need to start thinking about the people that you're in a relationship. Their higher power is their father. And they're going to come asking you, why are you treating my child this way? You understand? Don't come back here again. Thank you.
Thank you.
Thank you, Judge.
Anyone else ready?
Right.
All right. I will let them in. David Woodard. Thank you.
You're welcome.
Oh, I'm waiting. David hasn't
That's fine.
zoomed in.
Just for your clarification, though, he has the wrong case number at the top. The last digit should actually be a 4, not a 5.
Okay, so it should be side never, sorry, 792. What?
Instead of 97925, it should be 7924.
Okay. All right, so state, before we go on the record, Attorney Woodard, is just to see where we are or where the meeting of the minds are between you and the state. So state,
Yes, Your Honor.
do you object to removal of the GPS?
Yes, we do, Your Honor.
Okay, so then the next question is, do you have any objections to his seeking employment?
We do, because of the victim's concerns that when we spoke, I was on the hall, we spoke with her and she voiced her concerns about the safety of her child, the nature of the charge, the factual allegations that they have been presented. We would object to that as
All
well.
right,
Yes.
so this is what I want you to do. Mr. Woodard, do you have, do you have your cell phone or can the state call you right now and you're available to speak with them?
They can, Judge. We're not asking that it be removed. We're just asking for partial so that he can work. He's found a job already.
No. I want him to talk to you so he can tell you what the complainant's concerns are. And who knows, maybe you all can address that if you tell him what his work schedule is and the issues. And if you all can't come to an agreement, I'll make a decision.
Okay.
So he'll call you right now. So maybe that we can address the issue that they're saying that the complainant has. And if it can't be addressed, I'll hear it and make a decision. They're going to call you right now, Mr. Woodard.
Okay.
Yes.
Thank you.
Anyone else ready?
Ready on Mr. Potlon.
All right, could I see Mr. Potlon? All right, court is calling 2025 CR 0011193, State versus Oscar Potlon. All right, he can remain there. Yes. Could I have parties announced?
Megan Galloway for the state.
Dwight Chumley for the defense.
All right, are there any applications in this case?
No.
And are you Mr. Potlon? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Potlon, did you review the true bill of indictment with your attorney? Did you understand it? Did you understand it? I'm sorry, what?
Do you understand the indictment? He's very hard of hearing.
All right. Mr. Potlon, this document tells you what you're charged with. Did you review that?
Yes,
Did you understand it?
yes, I did, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, we're waiving the enhancements, Your Honor.
Any objection?
No objection.
Mr. Potlon, did you review this document? It's the admonishments. It tells you what you're charged with.
Yes, ma'am.
All right, you're charged with possession, penalty group 1, less than a gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea?
Yes.
Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow that plea? If I do not follow that plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, I do, I do.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is. Yes, Your Honor.
Mr. Potlan, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, you,
Anyone promise you anything other than the plea?
excuse me,
Did they promise you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
I think it's okay, man.
No, my question is, are you satisfied with your attorney?
Yes, sir.
All right, do you understand that if you're not a United States citizen, by entering this plea, you can be deported, not allowed re-entry or naturalization? Did you understand?
Born and raised here, man.
All right, did you understand?
Yes, I understand, yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page?
Ma'am,
The plea bargain, did you review that with your attorney?
she told me by people.
All right, so according to the plea bargain,
Yes, sir.
your punishment is to be assessed at 6 months in the state jail facility, $1,000 fine, and you're not applying for probation. Did you understand that?
No, ma'am, you didn't say nothing about no probation.
You are not applying for probation. Do you understand?
Oh, yes, ma'am.
Is that the plea?
Yes.
Defense?
It is state.
I'm sorry, state.
It is, Your Honor.
Did you review the waiver of appeal paragraph?
Yes, ma'am.
Did you understand by signing that the only way that you can appeal the court's decision is if I don't follow your agreement or there are some pretrial motions that I've heard and ruled upon? Did you understand that?
Yes, ma'am.
Have there been any such motions?
No.
Then how do you plead? Guilty, not guilty, or no contest?
Pretty guilty, ma'am.
State any evidence.
State offer states one in attachments.
Objection.
All right, state you may excuse. Did you review these stipulations with your attorney? It contains the police reports and the laboratory reports. Did you review that with your attorney?
Yes,
Did you understand it?
yes, ma'am.
All right, you understand by entering this plea bargain agreement, the state is not going to bring any witnesses into court. They're just going to ask that I read this document and see if there's enough evidence to find you guilty. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Only that he is in ill health. He has been in a hospital room now for over a week. I believe since his arrest. So if there's any way he can do some sort of unit there where they tend to the health of their sick inmates.
All right, the court will sentence you to 6 months in the state jail facility. There's $1,000 fine, time and money to run concurrently, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Thank you. God bless you too. All right, are you all ready on Ensiriaga?
Yes, Your Honor, if Mr. Woodard, thank you to make a law.
Okay. Let me just put this in here very quickly.
Sure.
I want to comment.
All right, the court is calling 2025 CR 007924, State versus Matthew Ensiriaga. Can I have parties announced?
Rick Pena for the state of Texas.
David Andre Woodard for Matthew.
All right, and Mr. Ensiriaga, if you'll show your video, please.
Yes, ma'am.
All right, the defense and the defendant are appearing by Zoom. Any objection?
Nothing more to state.
All right, the court is in receipt of a motion. The defense is requesting that the defendant be removed from full house arrest and be placed on partial house arrest and be allowed to work. And you have objections?
I do, Your Honor. We spoke to the mother of the victim in this case, and she voiced her concerns for her child's safety. Given what happened factually as alleged and given the charge that this defendant is facing against her, she was not comfortable with the GPS conditions being changed.
All right, defense, do you have any witnesses?
We do, Judge. I'd like to ask Matthew questions.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Matthew Suriaga.
All right, defense, you may proceed.
Matthew, have you found employment?
Yes, sir.
And where have you found employment?
I've gone through a temp agency, Rent Hill Staffing, and they helped me get jobs. And the job they helped me with get today is at it's a third shift at 5501 Business Park. It don't say the company's name. Oh, yeah, I don't say the company's name. Just the supervisor.
What days would you work?
Sunday through Thursday
What time?
from 10 p.m. to 6 a.m.
Okay, since you've been on GPS, have you had any violations?
No, sir, not that I know of.
Have you had any contact with the alleged victim since you've been on GPS?
No, sir.
Do you intend on having any contact with the alleged victim?
No, sir, I do not.
Are you asking the court to change your GPS conditions from full house arrest to partial house arrest so that you can work?
Yes, sir.
Judge, will pass the witness.
All right, any questions?
Yes,
State.
Your Honor. Mr. Instriaga, can you hear me?
Yes, sir.
You mentioned that you'd found employment. Was that today?
Yes.
So I'm assuming you had been looking through the temp agency like you had mentioned earlier, correct?
Yes, sir.
Okay, what kind of job is it again?
It's a warehouse job.
A warehouse job. Do you know who you'd be coming into contact with at this job?
Yes, I have the supervisor's information and number.
Okay. Does that employment involve you coming into contact with any minor children at all?
No, sir.
And did you make this employer aware of these pending charges against you?
Yes, sir. I told the staffing agency about it.
Okay. I have no further questions, Your Honor.
All right, anything else?
No, Your Honor.
All right, the court is going to grant partial GPS for employment only. And it will be defendant is allowed to work Sunday, from Sunday through Thursday, 10 p.m. to 6 a.m. with 30-minute How far is the employment from your home?
Let me look it up real quick. It is 18 minutes.
18 minutes? All right, with 30-minute travel time to and from work upon proof of employment and hours. So what that means is you cannot deviate and stop at McDonald's or stop anywhere else. You're only allowed to leave your house, to go to work, and to come back home. Do you understand?
Yes, ma'am.
If you violate these orders, if you stop at McDonald's or if you stop somewhere else along the way to work, there will be a violation. The court will receive notification and we'll have a hearing on whether or not you should be continued on bond. Do you understand?
Yes, ma'am.
All right, is there anything else?
Nothing from the state.
All right, thank you.
Thank you, Your Honor.
Anyone else ready?
No, we just needed some additional time.
All right, just 1 second. Yes, who are you here for?
Brian Martinez Mejia.
Let's see what page he is on. All right, thank you. Odyssey is taking a little bit of time to upload.
And that's all we need, Judge. Just a little bit of time.
All right. Yes,
So actually, they've tendered an offer that is within the realm. We have some differences of opinion. And so we're still going through it. And if we could be granted just a little bit of time so that we can discuss it in detail. So the formal offer was made today. We just need some additional time, a couple of weeks, 2-3 weeks to.
I'll recall you back on Thursday.
That would maybe, with what's going on, I'm not asking for what I believe to be a lot of time. I'm out next week. If we could be just 2 weeks maximum.
Are you out this week?
No, I'm not.
Because this was set, and the reason why I say that this was set for plea deadline day today. So I will see you all back on Thursday. Okay?
Okay.
All right, thank you.
Judge.
All right, is there anyone else remaining on the docket? All right.